Our last case this morning is 2019-961 in the matter of the determination of the existence of significantly excessive earnings for 2017 under the electric security plans of Ohio, Edison, the Cleveland Electric Illuminating Company, and the Toledo Edison Company. For the appellant, Ms. Willis. You'll have to turn your microphone on. There you go.
Thank you, Your Honor. Chief Justice O'Connor, honorable justices, may it please the court. I am appearing on behalf of the Ohio Consumers Council, representing 1 million residential customers of Ohio Edison, a First Energy utility. I would like to reserve 4 minutes for rebuttal. I will begin with some history that's related to today's issues. Last June, Your Honors protected consumers by striking down First Energy's so-called distribution modernization charge, finding it unlawful and unreasonable. Unfortunately, First Energy customers received no refund for the nearly $500 million they paid for the unlawful charge. Your Honors wrote that there would be no consumer refund because, in essence, the PUCO had failed to make the charge subject to refund. So First Energy enjoyed a windfall, and customers once again suffered the unfairness of no refund. But it gets even worse for consumers with the distribution modernization charge. Today's subject is the law's significantly excessive earnings test. Utility earnings are profits. The law is supposed to protect consumers from paying electric utilities too much profits. This morning, OCC will discuss how the PUCO took the law that is supposed to protect customers and turned it into a law that protects First Energy profits. Your Honors, we ask that you reverse and vacate the PUCO decision. Your Honors should remand the case to the PUCO, ordering it to rerun the profits test. This appeal presents a question of law. Your Honors are being asked to apply a statute that protects customers from paying their utility too much profits under an electric security plan. That statute is 4928.143F. The question presented is, was it legal for the PUCO to exclude electric security plan provisions and their revenues from the profits review? The answer is no. In 2008, the Ohio General Assembly passed an energy law which drastically changed the regulatory landscape for Ohio electric consumers.
Counsel, let me ask you, if we did what you asked and remanded it to rerun the test, including these amounts, would the result be any different?
Yes, Your Honor, the result would be different.
How I mean, as I look at the record, PUCO found that, what was it? There were two numbers, 17. What was the return on earnings that they found?
The PUCO found that the earnings from the electric security plan provisions minus the distribution modernization revenues were 12.22%.
Right, okay. So, but I think what the OCC said is if you included them, it would be 17.39%. Is that correct?
That is correct, Your Honor.
And that wouldn't be something that would be revisited on remand, is it?
Well, Your Honor, it would be revisited on remand. The commission made no...
Why is that? The numbers are the numbers, right?
Well, the commission made no determination. They didn't define what is excessive or what is significantly excessive.
Well, what about, I guess this is a finding where it says that where they said that either 17.22, which was the staff number, or 19.20 were okay. So even if you took the lower number, that is all we're talking about, the difference between 17.39 and 17.22, best case scenario for Consumers Council?
Well, Your Honor, let's go back for a moment. What I think, Your Honor, the finding that you're referencing is the commission in its order said that using the methodology suggested by either the PUCO staff or the company was appropriate. The commission never found that any earnings over 17% or any earnings over 19% is significantly excessive. They made no finding. They found the commission took the distribution modernization revenue riders out of the profits test. They cherry-picked it out of the profits test and then concluded that at 12.22%, there were no significantly excessive earnings. So the commission did not define what significantly excessive earnings would be. OCC's position in the case below, according to Dr. Dewan, was that any earnings over 15% would be significantly excessive. So the commission will have to, in the remand, determine what is significantly excessive and what is excessive. And that would be the difference between, if you accept OCC's position, that would be the difference between 15% and the 17%. But even at the 17%, if we go with the 17%.
Didn't the commission already find, though, that they didn't like your experts' methodology?
Yes, Your Honor, the commission did find Dr. Dewan's analysis flawed, but the reason that the commission found Dr. Dewan's analysis flawed was because Dr. Dewan followed the law and excluded the distribution modernization, or included the modernization revenues in his analysis. The distribution modernization revenues are a provision of the electric security plan. There is no doubt that they were. Because they had to be included in the excess profits test. We go to the statute, we go to the words of the statute begins, quote, with regard to the provisions that are included in an electric security plan under this section, the commission shall consider following the end of each annual period of the plan if any such adjustments resulted in excessive earnings. And as Your Honors are well aware, one of the key provisions included in First Energy's plan was the distribution modernization charge that Your Honors found to be unlawful. Note, Your Honors, that the statute lacks any exception allowing the PUCO to exclude earnings from provisions in an electric security plan, such as the revenues that are produced by the distribution modernization charge. The law requires the PUCO to calculate the earnings from the electric security plan provisions to make sure that windfall profits are not created for the utility to the detriment of the consumers. Nothing more and nothing less is required. The plain words of the law must be applied, not interpreted. The plain words are for including provisions of the plan with no exception. Let's take a look at what the PUCO did below that was unlawful. The PUCO used its own version of new math to reduce the electric security plan profits on paper, of course. The PUCO did that by excluding $58 million of revenue from the distribution modernization provision in First Energy's plan. That reduced Ohio Edison's earnings under the statutory profits test, even though Ohio Edison really did have that income. I call it First Energy math. And here's how the unlawful math works. If you reduce revenues on paper, that will reduce income on paper. If you reduce income, that will reduce profits. But just on paper, of course. In reality, Your Honors, you know that from your decision on First Energy's distribution modernization charge, that First Energy has customers' money. So what the PUCO did was the PUCO cherry-picked the distribution modernization revenues from the provision of the electric security plan and took them out of the profits test to achieve a desired result for First Energy at consumer expense. And we know that the PUCO desired a result because it wasn't shy in its order about announcing why it would exclude those revenues. The PUCO said in its order that including the revenues in the test would introduce an unnecessary element of risk to the companies and would undermine the purpose of providing credit support for the companies. In other words, the PUCO wanted to protect FirstEnergy from the risk of having to return profits to consumers. The PUCO was very successful in its scheme to protect Ohio Edison. The result was a paper reduction of Ohio Edison's profits from an outlandish 17%, as Justice DeWine noted, to 12%. Using FirstEnergy math, its new paper earnings were not significantly excessive, and that circumvented the profit test statute and harmed customers. Now, let's go back for a moment and talk about the law and what the purpose of the law is. In 2008, the Ohio General Assembly passed the energy law, and that energy law drastically changed the regulatory landscape for Ohio electric consumers. That energy law in many ways favors electric utilities to the detriment of consumers, but it did contain a protection. And one of those protections, as we discussed.
Please, let me ask a question. Don't we have a lot of case law deferring to the commission on rate of return issues?
Yes, Your Honor, there is a lot of case law deferring to the commission. However, this court has held that with respect to deference to the commission, that where the commission is construing a statute, it will not defer to the commission if the interpretation is unreasonable. Here, the interpretation was unreasonable. It was unreasonable because that interpretation undermines the entire consumer protection that's contained under 4928.143F. That statute is supposed to protect consumers from paying electric utilities for profits that are significantly excessive. The law serves as an after-the-fact limit on electric security plan rates that utilities charge customers. Under that law, an electric utility must return profits to consumers if the utility profits from the electric security plan provisions are significantly excessive. Here, the PUCO misconstrued the law. The PUCO erred at the outset of the test. The outset of the test is that you identify and calculate the earnings from the electric security plan provisions, not just some provisions, but all of the provisions. So the PUCO erred at the very outset. That particular sentence is the gateway to the profits review.
If we send this back and the commission essentially says, okay, we already found that 17.39 was a reasonable number, which is what our staff came up with. We'll use that. You say you back this out. It's 17.22% is what you think would be a reasonable rate of return, or I'm sorry, the actual rate of return. I mean, is that any kind of meaningful refund for customers?
Your Honors, any refund is meaningful. Any return to customers' money from the over $500 million they paid is a meaningful refund. Your Honors, it's about the law and the fact that the commission did not follow the law, that the commission excluded $58 million of revenue from the distribution modernization provision. Under the law, it was required to include that in the profits review. Because they did, that reduced their earnings under the statutory profits test. The purpose of the statutory profits test is to protect customers from paying significantly excessive profits to consumers through the electric security plan rates. If we allow the commission to exclude from the profits review provisions from an electric security plan, this time it's the distribution modernization rider, the next time it may be another provision. If we allow that, it undermines the very purpose and the essence of that consumer protection. PUCO is a creature of statute. They have no authority beyond that which is expressly granted to them in the statute. Here, there was a distribution modernization provision under which customers paid over $500 million. That was a provision of First Energy's plan. It should have been included. Those revenues should have been included in the profits review. Your Honor, in conclusion, we asked Your Honors to give consumers the protection of the law and give consumers justice under the law. Consumers did not receive either at the PUCO. If there's no more questions, OCC would like to reserve the remaining time for rebuttal.
Thank you, but you have no remaining time. Mr. McNamee.
Excuse me. Thank you, Your Honor. I'm Thomas McNamee here on behalf of the Public Utilities Commission. I'd like to reserve 5 minutes of my time for Mr. Lang, representing the First Energy companies. Your Honors, the Commission did exactly its job here. 4929 143F is a complicated statute. It's a complicated charge to the Public Utilities Commission to weigh quite a number of factors and make a large number of determinations, as discussed in the this court's Columbus Power decision, the only other case that really involves the significantly excessive earnings test. It's a complicated rate of return kind of calculation. The Commission went through its elements. It made the determinations, but when it implements the law, it has to implement all of it. Previously, you hadn't heard from Ms. Willis the balance of the statute. The balance of the statute is what's relevant here. It says that the Commission is to make adjustments for capital structure as may be appropriate, and consideration shall be given to capital requirements of future committed investments in this state.
Well, let me ask you about that.
Yes, sir.
Were there any specific findings about that, about future committed investments? Matt, I didn't see math. I didn't see any calculations on that. I just saw that. I just saw this kind of purpose language that it would defeat the purpose. But were there any specific findings about that?
Yeah, the companies here are engaged currently in a three-year program to spend $560 million on improving, on improving their distribution system. This is perfectly in keeping with the General Assembly's instruction. When we look at 492805D, it's the best example of this. The Commission is charged in any decision that it makes to encourage time-deferred pricing, smart grid installations, advanced metering infrastructure. That's what's going on now. We're 8 months into this three-year program where the company is spending $560 million, an amount that's dwarfs anything that's under consideration in this case. They're doing that for the benefit of the customers in the state. Customers haven't been robbed here. They're being benefited by this initiative. And the statute recognizes this. That's why it says consideration shall be given to capital requirements of future committed investments. This is what the General Assembly wants. That's why the Commission did this. This is a good thing. The Commission has done its job here. Excuse me, the analysis is complicated. It is essentially the Commission's bread and butter. This is very similar to the kind of analysis that goes on in any rate determination. Commission's been doing this for more than 100 years. It is the sort of area, as the Justice indicated earlier, where the court has traditionally deferred. It's a matter of tremendous expertise, tremendous experience, comparing relative risks, doing these various kinds of accounting calculations. It's all very important.
Counsel, I wonder though, have you answered Justice DeWine's question where he said, did the PUCO make findings, and can you direct us to those findings specifically about the capital investments?
What the Commission did was refer back to its determination that it had made about the necessity of these, the capital support in the earlier the earlier SSO case. So it's a reference back, and that's, in their view, that was enough to explain what they were doing.
But you didn't put that in the there's no calculation based on that. There's no comparison of other.
No. This is an adjustment that's done at the end of the test, essentially, at the end of the seat test. which is the way the statute lays it out. Once the other determinations have been made, then you look to what capital adjustments may be necessary in order to consider these future capital investment requirements. That's exactly what the commission did. So with that, Your Honor,
let me ask you one more question before you sit down. Did the commission make any findings on what was an appropriate return on investment?
Well, what it said was that either the company's approach or the staff's approach were acceptable. So it didn't pick between them. It said either were acceptable.
So if we remanded, does that mean that the commission would take the higher of the number, or would pick between them? What would happen on remand, assuming we agree with the Consumers Council on the other point?
I'm always hesitant to anticipate what the commission might do in a future determination.
Well, what do you think they should do from this record?
From this record, I don't see how you end up with a different result. As Mr.
What ROE number would you use, do you think?
I don't know which. Presumably, the commission viewed either of the numbers as being appropriate. So I don't know how it would choose between the two of them. That would be some determination it would have to make.
You think the commission would have to choose between those two numbers?
I think it's found that both those numbers were acceptable, and neither of them would lead to a refund.
Well, what about a 0.17% refund? Would that? How much would that be? Any idea?
I don't know. I don't know that you would get there. I am not sure of that at all. So, Your Honors, with that, I would simply ask that the commission be affirmed, and I would cede the rest of my time to Mr. Lang.
Mr. Lang.
Thank you. Good morning. May it please the court. My name is Jim Lang, representing Ohio Edison Company. Your Honors, OCC has limited its appeal here to the legal question of whether the commission has authority under the seat statute to exclude ESP-approved revenues when performing the seat calculations. This court found in the Columbus Southern seat appeal in 2012 that the seat statute is essentially a rate of return statute, and that requires the commission's technical expertise, and thus the court will defer to the commission's interpretation of the seat statute if it is reasonable. Here, the court should defer to the commission's reasonable interpretation of the seat statute as authorizing the exclusion of revenues during the calculations and regulatory adjustments that are required by the statute. We're not talking about something that happened outside the seat statute. We're talking about appropriate treatment of revenues and expenses during the calculations and adjustments that are required by the statute.
Well, I mean, shouldn't we really, I mean, I understand the idea that whether the number is 15 or 17 or 24, that's something within their expertise, and that might be something we should defer to. But just a simple matter of whether or not, and I am included, is included or not, seems like a question of law, doesn't it?
Mm-hmm. And Your Honors, there are multiple, Justice DeWine, there's multiple determinations that the commission has to make in the statute. In fact, in the Columbus Southern case, the court identified 4 separate determinations that the commission has to make in this case, starting with defining and calculating earned return on common equity. And the commission in 2010 had a generic, what was called, referred to as generic seat proceeding, where all the utilities involved, all interested parties, including OCC. And in that case, one of the many determinations that the commission made was looking at the statute requiring this calculation of earned return on common equity for regulatory accounting purposes. In doing the seat calculation, how is the commission going to perform that calculation? And the commission decided in that proceeding that that earned return in the seat review would exclude any non-recurring special and extraordinary items. There are other determinations, like other regulatory accounting determinations that are made just as part of that earned return on common equity calculation. But that was specifically a finding that the commission made that's relevant here, that there was testimony in the ESP4 case that these DMR revenues that OCC is complaining about qualified as an extraordinary item for regulatory accounting purposes. So that's the technical expertise that the commission is applying when it's doing this review here. The commission made that call that these DMR revenues are an extraordinary item for purposes of the seat test, and therefore are essentially drop out of the earned return on common equity question. Once you do that, that also flows through because you're adjusting not just the net income, but you're also adjusting common equity. That flows through to the capital structure adjustment. All of that is being done, Your Honor, because the statute requires a comparison between a return on equity for the utilities and basically a mean or a composite return on equity for a group of companies that have comparable business and financial risk. And that's the call that the utility.
That's not really what really happened, was it? I mean, PUCO didn't go out and look at the capital structure of different businesses and say we're going to approve this on that basis. They just essentially said because of the objectives we have, which would be good objectives, we're just not going to count this, right? Well, there really was all that calculation you performed didn't really happen.
Mm-hmm. And Your Honor, it does happen. And you can actually see,
maybe to get to the 17, to 17.22 or whatever, those numbers, 17.39, but it didn't happen here in deciding whether or not to exclude this. There was no real comparison. There was no calculation. It was kind of a policy judgment, wasn't it?
And Your Honor, just to make clear that the issue of like what's in the record and what the commission balanced in performing these calculations, that's not a question that OCC preserved for appeal. OCC is simply saying the commission had no authority whatsoever anywhere in the language of the statute to make these accounting determinations. But yes, the commission did have to make these accounting determinations. If you look in the supplement that we filed of the record, and I believe it's page 31 of our supplement, is where you see the start of the calculation, which includes all of the revenues, including rider DMR revenues. And then there are adjustments that are made that back out certain categories of both revenues and expenses from, the earned return on common equity is a fraction, basically. It's a numerator and denominator. So as part of that calculation, there are revenues and expenses that are backed out of that numerator and denominator as the commission is calculating that earned return on common equity. And then again, that flows through the capital structure. So that is in the record, Your Honor. Now, whether that's appropriate, we believe it was, because the commission could do that based on the testimony before it in the ESP4 case. That's what the commission was relying upon. The issue was, if you're approving these revenues, what is going to be the appropriate accounting treatment of those revenues in the seat proceedings? And that's what the commission addressed, is are these revenues, like some other categories of revenues, like some other categories of expenses, are they going to drop out of the calculations that the commission performs? This is no different than what the commission has done in every other seat proceeding since the ESP started and since the commission's been in existence. These are rate of return determinations. They're technical calls that the commission has always made. And in fact, even OCC's own expert witness in this case agreed that the commission has authority to make regulatory accounting adjustments. OCC's witness agreed that the commission has authority, that the authority that the commission has includes an adjustment to exclude non-recurring, special, and extraordinary items from Ohio Edison's earned return. Pardon me. OCC's witness simply disagreed with other witnesses as to whether rider DMR revenues are an extraordinary item. He agreed that the commission can make adjustments. He just disagreed that this particular revenue source qualified as an extraordinary item.
Thank you, Mr. Lang. You've used your time.
Oh, thank you, Your Honor.
Thank you. Counsel, you have used all your time. I'll give you 1 minute.
Thank you, Your Honor. The simple question put before Your Honors is whether the PUCO can exclude revenue from an approved electric security plan provision from the profits review. It cannot. It cannot do so as an adjustment. It cannot do so as a capital structure adjustment. Mr. McNamee talked about the capital structure adjustment being a consideration at the end of the test. That is correct. But at the beginning of the test is where the commission is determining the earnings from the electric security plan. And if it's a provision under the electric security plan, it must be included in the earnings. The PUCO must follow the law. Thank you.
Thank you. We'll take the matter under advisement. You'll be notified of our decision. Marshall, will you adjourn court, please?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.